There are real protections for California landlords, but there are also lines you must never cross, no matter what the tenant owes. California law gives landlords real tools. You have the right to evict for documented reasons. You may be exempt from rent control. You have lease clauses courts will enforce. The question is whether you've set them up correctly before a dispute starts. One of the most overlooked protections is the AB 1482 exemption. If you own a single-family home, a condo sold separately, or a property built after 2010, you may be exempt from California's rent cap and just cause requirements. But the exemption isn't automatic. You have to serve a specific written notice to the tenant. If that notice was never served, a court may not let you claim it. This is the single most common documentation gap we see in self-managed properties. If you need to reclaim your rental for personal use, California law gives you that right. In Oakland, 60 days written notice, relocation assistance per the rent adjustment program, and genuine occupancy as your primary residence for at least 3 years. Courts scrutinize these cases carefully. Now, the other side of the line. No matter what the tenant owes, there are actions California law prohibits absolutely, and the penalties are significant. You cannot change the locks without a court order. You cannot shut off utilities. You cannot remove the tenant's belongings. These are violations of Civil Code Section 789.3. They apply regardless of how many months of rent are owed. There is no exception. Here's how it typically plays out. Owner changes the locks, believes the tenant left. Within hours, the tenant calls police. Within days, a civil claim is filed. Now there are 2 legal problems instead of 1, and the tenant has leverage in both. The penalty under Section 789.3 is $100 per day from the first day of the violation. 2 weeks is $1,400, before hotel costs, storage, and attorney's fees. The locksmith cost $150. The legal exposure can be 5 figures. A voluntary cash for keys agreement is legal, voluntary, in writing, genuine choice by the tenant, not a pressure tactic. Not a substitute for the legal process if they say no. At all East Bay properties, we review AB 1482 status on every new property we take on. When tenants stop paying, we follow the legal process exactly. We have never advised a client to change locks or shut off utilities, and we never will. This wraps our May series on California eviction law. 4 weeks, 4 topics. Full written guides linked in the description. Questions about your property's exemption status or a difficult tenancy? Link in the description. All East Bay properties, protecting East Bay owners.